And pull your pants up. So, okay. Next time wear a belt, you're in court. Understood?
Yes, sir.
Good morning, Rob Jacob on behalf of Ms. Brookshire.
Marie Brookshire.
Judge states PCC, we're asking this matter for a preliminary exam. And
Discovery is complete.
Yes, Your Honor. I met with her at the jail last night. We went over the police report. I would ask if we could address bond.
I have a tether violation.
Judge, the only thing is, speaking with my client last night at the jail, is the violation is that she couldn't power up the tether. She's still wearing it. And she was released originally on PR bond with the tether. She had problems charging it. And I believe that's the violation itself. We're asking if the court would please consider just to really restore back to PR bond. I would ask for without the tether, but if it has to be the tether, if somebody could look at it, she's still wearing it. It doesn't work. So we just need to get that straightened out. For my client, the tether was acting up when she was brought into the jail. So okay. I just think the tether people have to either come and adjust it or get a new tether, or hopefully without a tether.
Did she contact the company when the alarm was going off?
Your Honor, I did, but my problem was I couldn't see very well because my contacts, and I accidentally typed in 8100 instead of 8160, and I had my dad looked at it, and we both double checked. And he couldn't see it. He put the wrong one. But I did leave 2 messages for Brian Levitt. He told me to charge it for 20 minutes. We agreed on 20. I did 35. I called him after to see what my percentage was. I left him a message. Then when it was going off, I called him again, left a message. When it was going off, me and my dad both attempted to call. And my phone was dead, so I couldn't get his number. But
I don't have any of that information regarding any call to community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well. And that's not what's reflected in community corrections violation.
Hang on. I have the sheriff's office report.
I have a bond violation of community corrections.
I do not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I got to figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, when you get a chance, that'd be great.
Yes. Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after meeting the corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the person that had to make contact with her while he was sending, he got an alert that the device had low battery. He attempted to contact her on the number that she provided him. That was unsuccessful. He started sending alarms and sirens repeatedly to the device. Finally, the defendant, finally, I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, excuse me, if it gets critically low, this will be contacted. They acknowledged this and the phone call ended. They then only charged it for 35 minutes. So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert for the defendant. All attempts to reach the defendant were unsuccessful. At 7:48 p.m., Washington County Dispatch was contacted, advised of the violation, and was asked to have an officer respond to take the defendant into custody. Contacted by Deputy Mace, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mace was told they needed to be arrested on the violation. The defendant had only charged for a total of 45 minutes in the last 5 days. At 9:05 p.m., the defendant was tracking at the Washington County Jail. So the device is working. In addition to this, my office just charged her with stalking. in a
What?
separate case. In addition to this, my office requested a $10,000 cash surety bond at the time of charging this case. This case being today's case, we requested the $10,000 cash surety on what she's before Your Honor.
Mr. Kirwald?
I'm keeping the same argument, Your Honor. I'm asking.
Okay, motion for bond reduction is denied. Bond will continue in this matter as revoked.
Judge, it's clarification. Is the bond, what are you, $2,000, 10%?
What do you have this on? I have 2,010% on this case.
And if she's released, it's on tether?
It's on tether. She'll have the same conditions.
Okay.
What? Oh, no, she is not gonna sit there and mouth me. Her bond now is 25,000,
Really?
10%. Yeah, really? You wanna keep going? I didn't think so. Have a good day.
25.
25, 10. Your name?
Gregory Williams.
Next time, long pants.
This courtroom moment unfolds as a tense and emotionally charged bond hearing that quickly spirals into a shocking display of authority, frustration, and consequences. What begins as a routine request for leniency turns into a dramatic reminder of how unforgiving the legal system can be when court orders are ignored, intentionally or not. The defendant enters the courtroom already in trouble due to a tether violation. Her attorney calmly explains that she was originally released on a personal recognizance bond, with the condition that she wear and maintain an electronic tether. According to the defense, the violation wasn't intentional. The tether allegedly failed to charge properly, and the defendant insists she made several attempts to contact the monitoring company for help. From her perspective, this was a technical issue, not defiance. But the tone of the hearing shifts the moment the prosecution begins to speak. The state lays out a very different version of events, one backed by reports, timestamps, and communication logs. The prosecutor explains that the defendant was given clear and repeated instructions on how to properly charge the device. She was told explicitly to charge it for 2 full hours and warned that allowing the battery to fall critically low would result in immediate consequences. Instead, the tether was charged for only 35 to 45 minutes total over several days. As the prosecutor continues, the courtroom grows tense. The monitoring officer describes sending alarms and sirens to the device, attempting to reach the defendant multiple times, and receiving no response. When contact was finally made, 6 hours later, it was from a different phone number. Even then, the instructions were repeated, acknowledged, and still not followed. The result? A confirmed violation, law enforcement involvement, and the defendant being taken into custody. What makes this case even more serious is what comes next. The prosecution reveals that additional charges have been filed, including a stalking-related offense. Because of this, the state requests a $10,000 cash bond, arguing that the defendant has demonstrated an inability or unwillingness to follow court-ordered conditions. To this point, the judge has heard enough. The judge denies the defense's motion to reduce the bond and makes it clear that responsibility lies with the defendant. Court orders are not suggestions. Monitoring conditions are not optional. Technical excuses do not override repeated warnings. Then comes the moment that shocks everyone in the courtroom. As the judge is issuing the ruling, the defendant appears to mouth off under her breath, visibly frustrated and unable to control her emotions. That single moment of disrespect changes everything. The judge immediately stops the proceedings. With visible authority and zero tolerance, the judge raises the bond from $10,000 to $25,000, enforcing stricter conditions and making it clear that courtroom behavior matters just as much as compliance outside of it. The message is unmistakable. Attitude has consequences. The courtroom falls silent. The judge ends the hearing sharply, reminding the defendant that this is a court of law, not a place for defiance, excuses, or disrespect. Even something as small as courtroom conduct and appearance is addressed before the next case is called. This case is a powerful example of how quickly things can go from bad to worse in court. A situation that may have been resolved with cooperation and accountability instead turns into a far more serious outcome due to poor judgment, emotional reactions, and failure to follow clear instructions. For viewers, this moment serves as a harsh but important lesson. The justice system runs on rules, responsibility, and respect. Ignoring conditions, arguing semantics, or showing defiance doesn't weaken the system. It strengthens the consequences. If you think court is just paperwork and talking, this case proves otherwise. One missed responsibility. One bad decision. One disrespectful moment. And everything changes. Subscribe for real courtroom drama, shocking judge reactions, and moments that change lives forever. Hit like if you believe court rules are not a joke. Comment below, was the judge right or too harsh? Turn on notifications so you never miss intense court moments.